Good afternoon. My name is Nia Wongset Yichi, and my teammates and I will be tackling the following contract problem. Clumsy Corp is a London-based company specializing in organic skincare products. It operates two primary business segments. The first segment involves selling premium skincare items within the United Kingdom to affluent clientele. These products are uniquely sourced from a supplier in Dystopia, a country known for its questionable labor practices. In March 2024, Clumsy received an unexpectedly large order from its high-end customers, who aim to present themselves favorably at a prominent charity gala. Clumsy sent confirmations to all clients for their orders. However, Clumsy's inventory was critically low, necessitating the immediate importation of additional products from Dystopia. Unfortunately, shortly after the order confirmations, the UK Dock Workers Union informed Clumsy that their members would refuse to unload imports from countries with poor labor practices unless Clumsy paid an extraordinary annual unloading fee of £100,000 to the union. Faced with this ultimatum, Clumsy opted to pay the fee but issued a statement to the union saying, "We are paying under protest and reserve our rights." In April 2024, the union's actions were ruled unlawful by the courts. Now, Clumsy's second business segment focuses on supplying UK-manufactured skincare products to retail shops in Wales. Deliveries are managed by Greedy Couriers Limited Company. Under a 2-year contract set to end in September 2024, in March 2024, Clumsy secured several profitable long-term contracts with new Welsh retailers. Upon learning of this, Greedy Couriers sent to Clumsy a letter indicating that they would cease deliveries to Wales unless a surcharge of £500 per load was paid starting in April 2024. Clumsy, unable to secure an alternative courier on such short notice, reluctantly consented to this revised arrangement but communicated to Greedy Couriers, saying that "We are very unhappy with your conduct and reserve our rights." Consequently, Clumsy paid an additional £150,000 to Greedy Couriers before the contract's expiration in September 2024. In October 2024, Clumsy contracted with a different logistics provider. Now, the question asks my teammates and I to advise Clumsy Corp whether it can recover the sums paid to the union and Greedy Couriers under the English law and the Malaysian law. Now, I would like to invite my teammate Amira to address the problem on the English law.
Hello, my name is Noramira Patricia Muhammad Ridwan, and I will be discussing the first issue, which is between Clumsy and the union. The issue we will be discussing today is whether Clumsy can recover the sum paid by showing that he agreed to the contract under duress, specifically economic duress, which is recognized under English common law. According to Burroughs, a contract is voidable when a claimant was induced into a contract due to an illegitimate threat known as duress, made by the defendant, be it the contracting party or in this case, a third party. The definition of duress can be found in the case of Hallmark Group and Trexco Enterprises, whereby a threat to break a contract will be regarded as illegitimate, particularly when the defendant must know that it would be a breach of contract if the threat were implemented. As such, there are 3 types of duress, which are duress to person, duress to goods, and economic duress. However, in Clumsy's case, we will be discussing economic duress. McKendrick defined economic duress as one party using their superior economic power in an illegitimate way to coerce the other contracting party or the other contracting party to agree to a particular set of terms, whether a variation of an existing contract or a new contract. Clumsy's case falls under economic duress, as the union is asking Clumsy to pay £100,000 and not threatening to destroy Clumsy's goods, which would make it fall under duress of goods. Economic duress was first recognized in the case of the Sibone and the Sibontree, where Justice Kerr recognized economic pressure could amount to duress. Now I will be discussing the rule. There are 4 elements of duress that must be proven by Clumsy for a successful plea of economic duress to recover the sum paid. These elements were established in the case of Pao On and Lau Yu Long, which are the overborne bill theory, the illegitimate threat theory, causal link, and procedural unfairness. I will be talking about the overborne will theory. The theory was refined in the Universe Sentinel case. Explains that the victim's will was overborne by duress, which makes the contract voidable, as there was no free will or consent for the agreement to the contract. There are 4 factors to this theory, which is, the first one is, did the innocent party protest before agreeing? The answer is yes. Clumsy protested before and at the time of making the payment. They issued a statement saying, we are making payment under protest and reserve our rights. This shows that Clumsy did not willingly agree to the extra £100,000 fee, and they made it clear that they were unhappy and felt forced to the situation. The second factor, did he have an alternative course of action? The answer is no. Clumsy did not have an alternative course of action. The facts explicitly state that Clumsy's inventory was critically low and required immediate importation of the products. While the facts do not explicitly mention whether Clumsy could have used a different port or taken other steps, it is strongly implied that other realistic options were not available. If the products were not loaded in time, Clumsy would likely face serious problems such as losing customers, damaging its reputation, and suffering financial losses, especially with the important orders for an upcoming charity gala. This made it practically impossible for Clumsy to find an alternative in time. The third factor is, did he have access to independent advice? The facts do not clearly mention if Clumsy got legal advice before paying, but due to the urgency of the situation, it is likely that Clumsy did not have enough time to stop and get advice before making a decision. And the fourth factor is whether after entering the contract, did Clumsy, within a reasonable time, take any steps to avoid the contract? The answer is yes. Clumsy took clear and immediate steps to show they did not agree with the payment. They protested at the time of the payment and reserved their rights. Later, when the courts declared that the union's actions were unlawful, it supported Clumsy's position, which is whereby Clumsy's early protests and later legal actions show that they acted within a reasonable time to change the contract. As such, Clumsy fulfilled the 4 factors established. Next, my teammate Dareen will be explaining the second half of the first issue.
This is Dareen Ali Mahmoud Ayat. Now I'll be discussing the legitimate threat theory. The Universe Sentinel case introduced the legitimate pressure theory, which helps decide whether a threat is legitimate. Here we will be looking at the nature of the pressure and the nature of the demand, including whether it was lawful and made in good faith. First, was there an actual or threatened breach of contract? In the Atlantic Baron, shipbuilders threatened to stop working unless the owners paid more, even though a price had already been agreed on. The court ruled that this kind of threat, where one side forces the other to change a deal, can amount to economic duress. Now, in this case, although the contract wasn't directly between Clumsy and the union, there was a clear threat to the breach of the contract between Clumsy and its clients. The union threatened not to unload Clumsy's important products unless they paid £100,000. This was a new unexpected demand, so this element is likely met as there was a clear threat that would impact Clumsy's obligation to its own clients. Second, did the person applying the pressure acted in good faith? This was explained in Time's Travel, where the court could held that there was no economic duress, because the defendant generally believed that they owed nothing, so their pressure was lawful and made in good faith. In this situation, however, the union threatened to stop doing its job, which was unloading the goods, unless Clumsy paid £100,000. They knew Clumsy was desperate to get their products delivered in time for important orders. This was later ruled unlawful by a court in April 2024, confirming that the union's threat had no legal basis. The court's decision makes it clear that the union's actions were reasonable and therefore weren't made in good faith. The demand was both unfair and unlawful, imposed at a time when Clumsy was vulnerable, and as such, it meets the requirements of illegitimate pressure needed to prove economic duress. Third, did the victim have a realistic practical alternative? As previously mentioned, Clumsy did not have a practical alternative. The demand came with time, pressure, and the facts of the case mentioned that the situation was necessitating the immediate importation. So there was no other realistic course of action for Clumsy. Fourth, did the victim protest? The facts state that Clumsy issued a statement saying it was paying under protest and reserved the right to when making the payment. This shows that Clumsy clearly protested. Fifth, did the victim affirm the contract? Clumsy reluctantly affirmed the agreement under protest because its situation required it, but it wasn't a lawful or voluntary affirmation. They also reserved the rights to later challenge the validity of the contract. It's important to remember that no single factor is decisive on its own. The courts will consider the full facts of the case. Now I'll be explaining the causal link. In Avian Luck, the court confirmed that for economic duress, there must be a significant and operative link between pressure applied and the agreement made. In Heighton essay, v. Peter Creamer, the claimant had to show they wouldn't have entered the contract but for illegitimate pressure. The same idea was confirmed in Times Travel 2. Now I'll apply these facts to Clumsy's case. Clumsy only paid because the unions threatened to stop unloading the goods. If they hadn't agreed, the products wouldn't have been delivered, which would have badly hurt their business. The fact that Clumsy protested immediately shows they didn't truly agree. Also, there was no other practical options available, meaning unions' pressure directly caused the payment. This satisfied the requirements for causation. Now I'll be explaining procedural fairness. This point doesn't focus on whether the terms of the contract were fair or beneficial, but whether the way the agreement was made was fair. Since Clumsy was forced into agreeing because of an illegitimate threat, the element is established. Now I'll be discussing the remedies available to Clumsy. When a contract is made under duress, it isn't automatically void, it's voidable. This means Clumsy can either choose to cancel the contract and ask for their money back or leave it as it is. The first remedy is the right to resign. Clumsy has the right to resign the contract because the payment was made under duress. If they choose to resign it, they can demand the £100,000 to be returned. The second remedy is the bars to rescission. If Clumsy had affirmed the contract by accepting the situation without protest or by delaying unreasonably, they might have lost the right to resign. However, Clumsy protested straight away and reserved the rights, so this bar doesn't really apply. The third remedy is restitution. The main remedy here is for the union to repay Clumsy the £100,000. In cases of economic duress, courts typically order restitution, returning the benefit wrongly obtained. I'll briefly go through the defenses that the union might raise. The first defense, if the payment was voluntary. The union might claim Clumsy agreed to pay willingly, but this would fail because Clumsy objected immediately and said they were paying under protest. The second defense, if it was a normal commercial pressure, the union could argue that this was just tough business negotiation as allowed in Avian Luck, but this would fail because the pressure was unlawful, refusing to unload goods, and that was later ruled illegal. The third defense, if there was other practical alternatives, they might argue Clumsy could have delayed shipments or used another port, but realistically, with urgent customer orders and the union controlling the docks, there were no other practical alternatives. The fourth defense, delayed taking action, with other words, affirmation. The union might claim that if Clumsy waited too long to challenge the payment, they accepted the contract. But Clumsy protested immediately when paying and reserved the rights. The facts mentioned that in April 2024, shortly after the March 2024 payment, the union's actions were ruled unlawful, while the exact time between the payment and legal ruling isn't specified. It seems to be within a reasonably short and acceptable time frame. There's no indication of a long or unreasonable delay, so this defense would likely fail. So now, in conclusion, if Clumsy court can prove these factors, the illegitimate pressure, lack of alternatives, clear protest, causation, and procedural unfairness, it would be successful in recovering the £100,000 it unwillingly paid to the union under economic duress. The union's possible defenses are unlikely to succeed. The most suitable remedy would be restitution, allowing Clumsy to recover the £100,000. Now, Yali, my next teammate, will be discussing the Malaysian part of this issue.
In Malaysia, the terms duress and coercion are used interchangeably. Compared with the English common law position, the Malaysian approach to coercion is governed by legislation, primarily the Contracts Act 1950. This act, recognized as a codification of English common law, has similarities in the way they regard duress, but they operate in considerably different ways and allows for more routes to establish duress in contrast to the UK. Malaysian law addresses coercion in three portions such as Section 15, 19, 66, and 73 of the Contracts Act 1950. Now, focusing on the question, the main issue at hand is whether Clumsy can recover the $100,000 it paid under credits to the Dock Workers Union, who threatened to refuse unloading Clumsy's imports under Malaysian law. Now, under Section 15 of the Contracts Act 1950, coercion is defined as committing or threatening to commit acts forbidden by the Penal Code or to unlawfully detain or threaten to detain property to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement. If consent is not free under Section 14, subsection A, and coercion is proven, Section 19, subsection 1 renders the contract voidable at the option of the party who was coerced. Further, if the contract is rescinded by any party receiving any benefit under the contract, must restore the benefit or compensate the other party for it under Section 66, so as to return both parties to their original position. Additionally, Section 73 also applies in situations where money or property has been paid or delivered under coercion, providing a statutory right of restitution. Notably, the term coercion under this section is independent and is not limited to the definition stated under Section 15 as confirmed by Chin Nam Development and Tai Kim Chu. Although Section 15 does not expressly mention economic duress, Malaysian courts impliedly recognizes economic duress in cases such as Bergamo Development versus Ek Development under common law by virtue of Section 3 and Section 5 of Civil Law Act 1956. The workers' refusal to unload the goods created severe commercial pressure on Clumsy, who had already confirmed the order with his clients, leaving him desperate in need of union service without any alternative options to unload his goods. This led Clumsy to accept the demand without his free consent, pushing the situation into the realm of coercion. Although at first glance, this case may not fit the requirements of Section 15, as it does not have an obvious involvement in penal code offences or an obvious unlawful threat to detention of goods. The situation changed when the court ruled union actions unlawful in April 2024, thus distinguishing the case at hand from the earlier Malaysian decisions like Teguan Trading and Hydrotech Engineering, where refusal to act or deliver goods one has legal control over was found lawful. Here, even though the union did not own or legally control Clumsy's goods, they used their labor as leverage to make the goods inaccessible. The union's refusal to unload could be seen as an unlawful strike under Section 2 and Section 45, subsection 1, sub B of the Industrial Relation Act 1967, further reinforcing the court's finding of unlawfulness, meaning that Clumsy can argue that his case satisfies the elements under Section 50, rendering the agreement voidable under Section 90, and he can claim restitution under Section 66. Even if the courts find that Section 15 does not apply strictly, Clumsy could also rely on Section 73 of Contracts Act 1950. This is comparable to illustration B to Section 73, where a consignee having paid an illegal charge under pressure to release withheld goods was entitled to recover the excess amount. Similarly, Clumsy's payment was also made under protest in order to access his goods, which the union had rendered inaccessible by withholding their services to unload them. This would allow them to argue the coercion without having to prove its elements in detail under Section 15 and without an contract. Additionally, economic duress under common law can also apply, though it's not the easiest route. Cautiously recognized by Malaysian courts in cases such as OCBC Securities, Sendirian Berhad versus and Koki Quad, it is established only when the guidelines laid down in Power are satisfied, as affirmed by Justice James Wu. And even still more famous fail, as seen in cases such as Zainal, Abi bin Muhammad, and Lee Lin Hon. Regardless, the issue at hand, Clumsy had no alternatives, acted under alleged repression, and had paid under credits, satisfying the requirements of economic duress. It demonstrates a coercion of will, making the agreement voidable under common law principles. However, pursuing a claim under economic duress in Malaysia is highly discouraged due to the high rate of unsuccessful claims. Hence, the appropriate legal route depends on Clumsy's objective. If Clumsy intends to rescind the agreement, then he must argue the case under Section 50 and Section 90. On the other hand, if Clumsy's only intention is to recover the amount they paid, Section 733 would be the most safest and straightforward approach. Moreover, due to its low success rate in Malaysia, economic reviews should only be used as a secondary argument rather than a principal basis for recovery. Thus, the best course of action for Clumsy to recover his 100,000 would be to argue the case under Section 73. As this provision deals directly with the restitution of the money, perfectly fitting Clumsy's requirement for the claim. Now, my friends Mia and Husna will be discussing the next issue under United Kingdom.
Hi, my name is Husna Husna, and now I will be talking about the second issue, which is whether greedy carriers' action constitutes economic duress. So, in the journal article, The Recognition of Economic Duress in the Peace Law System by Science of the Law Journal 2024, it defines that economic duress can be explained as commercial duress, which refers to illegal intimidation that threatens to cause financial losses to someone that they are unable to exercise their will. We can also refer to the journal article contracting under Pressure, A Theory of Duress, Cambridge Law Journal 1997 by Ace A. Smith, which states that in certain circumstances, the fact that an agreement is made under illegitimate pressure is sufficient reason to invalidate what would otherwise be a good contract. In this issue, if Clumsy is able to prove that the later agreement was made under illegitimate pressure, or in other words, duress, such an agreement is voidable. It also applies to the modification of contract terms as cited in the Atlantic Baron, which in this case, Clumsy and Greedy already had a 2-year contract, then subsequently modified the terms of the contract by increasing £500 per load paid to Greedy in April 2024. Let's move on to the first element of duress. Firstly, we'll be looking into the overborne will theory, which can be seen in the case of Universal Sentinel, and the case of Plow On expand on the specific factors required. At the same time, not all factors need to be met. Courts will view the overall position of the victim from these factors. The first factor is, did the innocent party protest before agreeing? In this issue, Clumsy stated that they were very unhappy with Greedy's action and reserved their right, but this is unclear whether this is occurred prior to the agreement. The second factor is, did he have an alternative course of action? For instance, satisfactory legal compensation, which we can refer to the journal article by Andrew Pham. Not in this issue, Clumsy did not have a practical alternative course of action as they were unable to secure a carrier on short notice. The next factor is, did he have access to independent advice? The facts are silent on whether Clumsy sought legal advice before agreeing to these very terms. The last factor is whether after entering the contract, did he within a reasonable time take any steps to avoid the contract? This is arguably yes, as Clumsy protested by explicitly stating reluctance to accept agreement and taking actions to recover sums, presumably during October 2024, 1 month after the contract expiry, may be deemed as avoiding the contract within a reasonable time. While not all the factors are conclusively satisfied, the majority is fulfilled, leading to a high possibility of establishing an overborne will mentioned in Plow On case. Next, we can take a look at illegitimate theory under the Universal Sentinel and D. Petroleum. The first factor is whether there has been an actual or threatened breach of contract. There was a threatened breach to contract, as Greedy stated that they would cease deliveries despite contractual obligations, whilst demanding for an additional £500 per load made. That equals to threatened breach of contract. The next factor is whether the victim had realistic and practical alternative. As mentioned before, unlikely as Clumsy was unable to secure an alternative carrier on short notice. The third factor is whether the victim protested. This has been mentioned earlier as well, when Clumsy arguably protested by stating that they were very unhappy and reserved their rights as they reluctantly agreed with Greedy's new terms. The last theory is whether the victim affirmed and sought to rely on contract. The fact that Clumsy decided to contract with different logistics provider and currently seek to reclaim the additional sums paid to the Greedy made sure that it did not seek to rely on the contract. Next, I will be passing to my teammate Mia.
Thank you very much, Krishna. Now I will be continuing with the following element, which is causal link, as stated in the case of Vivian Luck. It says that a legitimate threat must be a significant reason for the victim to enter into the contract. This is likely to be fulfilled as it seems that Clumsy only agreed to Greedy's threat due to the lack of practical alternatives at the moment. However, the facts are silent on whether Clumsy had other ulterior motives or benefits into entering the subsequent agreement. Moving on to the final element, which is procedural fairness. Considering that Clumsy's dispute against Greedy is over matters that transpired before the subsequent agreement, Clumsy's claim would likely fall under dispute over procedural fairness, irrespective of substantive fairness of the agreement. All in all, similar to the previous issue, Clumsy is likely to fulfill all four elements to prove economic duress. Moving on, in assumption that Clumsy manages to establish economic duress to the courts, Clumsy would have the right to rescind the contract as stated in the case of the Universe Sentinel. If Clumsy manages to prove economic duress, the new contract is voidable at Clumsy's discretion. The new variation of the contract can be rescinded, in which both parties will be reverted to the original positions prior to the subsequent agreement, in which Clumsy can claim for recovery for additional pay charges. Moving on, there are several defenses that Greedy may raise, which are bars to the decision. Greedy may claim that Clumsy took a delay in taking action, which is equivalent to affirming the subsequent agreement. Again mentioned in the case of the Atlantic Baron, the claimants in this case were deemed to affirm the very contract partially due to a delay in 8 months after the contract expiration before filing a claim. However, the facts are ambiguous on when exactly Clumsy is taking an action against Greedy. However, with the presumption that Clumsy is taking an action 1 month after the expiry of the contract in September 2024, it is likely that the courts deem this to be a reasonable time frame to take such action in comparison with the judgment in the Atlantic Baron. In conclusion, Clumsy would likely be able to prove all the elements of duress and initiate an action against Greedy. With Greedy unlikely to be successful in defending such claims, Clumsy is likely to succeed in this action. As a result, Clumsy would also be able to claim for rescission and reclaim the additional £150,000 that was paid to Greedy. That will be all from me. Thank you.
Under Malaysian law, in order to understand whether the sums paid are recoverable, we must understand the nature of consent. In this case, Clumsy already had a contract with Greedy for delivery of their products, but only agreed to change the terms of their contract under protest. This protest shows that consent was not given freely. Section 10 of the Contracts Act states that an agreement is only a contract if it is made with free consent, and Section 14A states that consent is not free if it is caused by coercion. Section 15 defines coercion, and the acts which constitute coercion under Section 15 are similar to the principles of duress to person and duress of goods under English common law. However, Section 15 does not explicitly provide for economic duress. On application, Greedy's actions cannot be categorized under the Act which constitute coercion in Section 15. This is because Greedy is threatening to breach their contract and halt deliveries, which does not fall under the purview of the Penal Code as it is only a civil offense. Further, they only threaten to halt deliveries, not keep any product that may already be in their possession. Thus, Greedy's actions do not equate to detaining or threatening to detain Clumsy's property. As such, the elements of coercion in Section 15 are not satisfied, so Clumsy cannot pursue their case under this statute. Clumsy can, however, try to still prove coercion under Section 73 of the Contracts Act and economic duress under common law. Section 73 provides a statutory right to restitution in cases of coercion, and the case of Chin Nam Bee Development and Tai Kun Chu established that Section 73 follows the ordinary and general definition of coercion instead of the definition provided in Section 15. On application, this may be more suited to Clumsy's issue because it fails under the strict definition of Section 15. Sri Bala Murugan argues that the illegitimate pressure in commercial situations, as seen in Clumsy's case, should be covered under the general definition of coercion, and thus Section 73 should be applicable to Clumsy's case. Further, Clumsy's case is quite similar to Chin Nam Bee because in both cases, one party is threatening to cancel their existing contract unless an additional amount of money is paid. And in Chin Nam Bee, the Malaysian courts decided that the defendant was required to repay the amount of money that was lost. So this shows that Clumsy would be successful in recovering the amount of money that they paid to Greedy after the issue of coercion. It's proven under Section 73. However, academics like Dr. Abdul Ayos argues that Section 73 is provided in Part 6 of the Contract Act, which is concerned solely with the relationships that resemble contracts, not contracts themselves. So this provision may not be successful because Clumsy and Greedy already had a pre-existing contract. In conclusion, Clumsy may be able to recover the money under Section 73, especially because it is provided explicitly to recover money. However, academics have criticized Section 73 as being restrictive to existing contracts, so it may not be successful. The second thing we will will discuss is economic duress under common law. There are no statutory provisions that provide for economic duress in Malaysia. However, economic duress has been recognized and considered in courts. However, its development has been much more restrictive than its counterpart under English law. In the cases of Muhammad Farid Subramanian and Nazar Motor, and OCBC Securities and Koh Kee Huat, the courts applied the 4 elements test established in the English case of Pao On to test economic duress. And in the case of Bergama Development and Ek Development, the courts applied Pao On and allowed the defense of economic duress because they believed that the defendant had knowingly used the plaintiff's financial standing to induce him into further contracts. Bergama Development also applied the principle of substantive unfairness, which was established in Miriam Sebastian and Stevenson. In that case, courts ruled that the unfairness of terms could prove that coercion took place. This is completely different from English courts, where they only care about procedural unfairness. However, it shows that Malaysian courts will take into consideration the unfairness of terms of a contract. On application, as we've established earlier and in the English position, Greedy exerted illegitimate commercial pressure on Clumsy and thus induced them to agree to the change in the terms of the contract, which constitutes economic duress under the English principles. Due to lack of statutory provisions, we must look at the relevant case law to understand whether economic duress would be applicable in Malaysia. The facts of Muhammad Farid Subramanian are similar to Clumsy's situation, as it concerned a variation of the original contract signed allegedly under economic duress. In that case, courts rejected the defense of economic duress because they believed that there was no signs of protest before, during, or after the signing of the contract. However, Clumsy explicitly signed under protest, and it was communicated to Greedy, which shows that Clumsy didn't have sufficient protest. Further, applying the principles of Pao On, as Malaysian cases courts have done before, Clumsy sufficiently displayed their objection to the new terms. Clumsy had explicitly communicated their protest. They had attempted to find alternative delivery carriers. However, it is not clear whether Clumsy sought independent advice, but from Clumsy's discontinuation of renewing their contract with Greedy after it expired in September 2024 shows that Clumsy was trying to quickly distance themselves from Greedy and this existing contract. So they were trying to avoid the contract as soon as they legally could. So most of the principles of Pao On are covered in Clumsy's case. Additionally, in Bergama Development, applying Bergama Development, Greedy also had sufficient market knowledge to know that Clumsy could not reject their change, the variation of contract, because it would impact their new contracts with New Welsh Development. So they knew that Clumsy would be forced to agree to their new terms. And applying the principle of Miriam Sebastian, Clumsy lost an additional £150,000, which shows that the terms were extremely unfavorable for Clumsy, so there is no way that they would have signed it on their own accord. In conclusion, the culmination of the principles of Pao On, Bergama Development, and Miriam Sebastian shows that Clumsy was certainly coerced into the second contract under the economic duress. Thus, Clumsy will be able to pursue a case under economic duress. However, Malaysia's approach to economic duress is still very restrictive, so it may be difficult to actually win and regain the sums lost under economic duress. So it would be our advice to pursue the case under Section 73, as it provides a direct and statutory right to restitution, and it would be the best pathway for Clumsy to effectively recover the amount of